Attorney General Gary King speaks often in public about the state's Open Meetings Act, known as OMA, and the Inspection of Public Records Act, known as Ipra. They are commonly referred to as the Sunshine Laws. State agencies have a point person who is specially designated to handle all requests for public information.
One of the most important things about Ipra is the requirement to have a custodian of records, one person in your agency who is, if somebody comes and says, I want records, they know that there's one person that they can go to and say, I need these records, and that person has the responsibility for all these other things, the 3-day letter and making those requests happen. So from my perspective, that's kind of the heart of the modern Inspection of Public Records Act, is that there's somebody that has responsibility to make all of this happen.
Attorney General King often explains to people how the AG's office handles OMA and Ipra complaints and violations.
One of the biggest penalties, I think, from the Open Meetings Act is the part of it that says that any action that's taken in a meeting that's not a valid open meeting is void. And we have sort of an ongoing battle going. Anybody here from Rio Rancho? Okay, I can talk about them a little bit now. We have sort of an ongoing battle with Rio Rancho because they terminated their city manager, and we got a complaint in our office, and we sent them a letter, and we said we think that that this was not a valid open meeting where you terminated your manager, and so our position is that that wasn't a valid termination. And for us, it's sort of the end of it, but I assume that for the city manager, that gave him a really good cause of action for why they should pay him back wages for 9 months or whatever, which is sort of how long it took to sort that out and decide that it wasn't an open meeting. So once again, there can be fairly significant monetary sanctions for violating the act.
Most Open Meetings Act violations are easily remedied, but sometimes a public body can get itself into hot water by not following the law.
I'm guessing in about 90% of the cases, we review the facts that we have, and we send a letter out to the agency where the complaint has been made, and we tell them either, hey, you know, these issues have been raised. We think that this raises an open meetings question. We think that you should address it. Let us know how you've addressed it in a lot of cases. And sometimes I think we probably look at it and we send a letter back to the complainant that says, we just don't see anything here that indicates that there was a violation of the Open Meetings Act or the Public Records Act. So a lot of those cases get solved with a simple letter, one way or the other, like that. Occasionally, the agency, say a city council or something, will send us a letter back that says, no, we don't really think we violated the act, and here's our side of the story. We really like to try and get both sides of the issues. And once again, a lot of times, if they have some documentation that shows how they did that, maybe somebody was complaining that there wasn't adequate notice of a meeting, and the city council, you know, their city clerk can send us something that shows all of the different notices that they did, and we look at that and say, well, no, that seems to be sufficient. And once again, we'll write a letter back to the complainant, usually in those cases, that says, we've received this information from the city. We think that this is sufficient. We think this closes the case. So in a few cases, it gets more involved in that. In the case of Rio Rancho, and I think all of these things are public, so I can talk about them. I think, you know, we sent them a letter, said we think you violated the Open Meetings Act. They sent us a letter back and said, no, we didn't. Besides that, you know, we don't even think that you should be sticking your nose in our business. So that happens. That actually is not a real good way to get on the good side of the Attorney General's office. We actually proceeded with some various actions that we thought might be necessary to enforce the act, and in this case, and here's another good thing about the Open Meetings Act. Once they realized that we were serious, I think they did decide to have another meeting and cure the open meetings violation.
When the AG's office determines that there has been a violation of either of the Sunshine Laws, the advice is to act quickly to remedy the violation in order to avoid monetary damages.
I think that in all cases that public bodies could minimize their potential damages by once they realize that there's a complaint, by sitting down and trying in good faith to address those right away. Because you're right, I think if you wait a year to address those or a year and a half to address those or something, then the potential for you, if you lose the case in court or if there's some other reason that you're not successful, then it could be a lot of money. And so my personal philosophy is that if everybody sits down at a table and in good faith decides here's how we're going to cure this, that you can avoid a lot of big problems, further down the line.
The Attorney General urges government bodies to be upfront about their public business dealings and is not shy about spelling out what he means.
Open meetings means open meetings, that every bit of business that's discussed that impacts the public by a public body ought to be available to members of the public. And there's a good philosophy that I always tell everybody when I was a legislator, that if I was embarrassed to vote a certain way on a certain bill because I knew that my constituents wouldn't like it if I voted that way, well, then I shouldn't vote that way. I mean, that's how representative government works by and large. If sometimes I know that they won't like my vote, but if I can go explain to them this is why I voted the way that I did, then I think that that's good government. But if you, so my number one level is if I would be embarrassed to tell my constituents why I was doing what I was doing, then I shouldn't be doing it. Now my higher level order than that is if I would be embarrassed to tell my mother why I was doing what I was doing, then I really shouldn't do it. So, and there are a lot of public officials. Think of Elliot Spitzer. If he had used that, thought, how will I explain this to my mother? He probably would still be the governor of New York.
There are certain types of information that are exempted from disclosure under the Open Meetings and Inspection of Public Records Acts. And Attorney General King says public officials should familiarize themselves with those limited exceptions.
We recognize that there are reasons, potential litigation, investigations by investigative agencies, all those kind of things where the information should not be public. But those are all set out in exemptions in the acts, either in the Open Meetings Act or the Inspection of Public Records Act. And our position in the Attorney General's office is if there ain't an exemption, you can't do it.
Once again, this session, the Attorney General's office will ask the New Mexico legislature to consider updating the Sunshine laws to have them more accurately reflect the advancements in technology.
We're actually going to go to the legislature this year and ask for a change in the definition of request so that it includes requests that are made by, actually fax requests are probably okay already, but by various electronic means. Now, the request will still have to include all of the information that you have to have, the name of the requester, information where they can be contacted, so that you can get back to them with regard to that. It also certainly will be, and this is one of the big questions, but those electronic requests will have to be directed to the right person. If you want documents from the Attorney General's office, it doesn't help you to send an email to the Attorney General asking for the documents. You got to send them to the custodian of records. Now, there's actually a little blurb in the law that says if you're in an agency and you're not the right person, you got to forward it to the right person. So, frankly, if somebody sends me a request, I probably would send it to our custodian of records. And it is our opinion right now that if agencies want to take email requests for documents, that they can, and we do in the AG's office. We actually accept email requests for documents. But one of the fairly big changes that we're going to ask the legislature for this year is just to make it clear that electronic requests are sufficient.